Colorado Rules of Evidence with rule amendments effective July 2021. Article 1, General Provisions. Rule 101. Scope. These rules govern proceedings in all courts in the state of Colorado to the extent with the exception stated in Rule 1101. What is this Rule 1101 about? Rule 102. Purpose and construction. These rules shall be construed to secure fairness in administration, elimination of unjustifiable expense and delay, and promotion of growth and development of the law of evidence to the end that the truth may be ascertained and proceedings justly determined. Holy shit. Pay attention, district attorneys of Colorado. Why do we have the rules of evidence? Why do we have the rules of criminal procedure? Why do we have the rights and freedoms? Why do we have the criminal code? Why do we have Colorado law? It can be summed up in Rule 102. Rule 102 of Colorado's Rules of Evidence. So this is just one chapter, one section of Colorado law, but the purpose of construction for the Colorado Rules of Evidence is as follows. These rules shall be construed to A, secure fairness in administration. Fairness. So that means if somebody felony menaced me, then they would have to go through the same process that I've gone through, right? Fairness in administration. What's good for the goose is good for the gander. That's due process. Number 2, elimination of unjustifiable expense and delay. You don't want to waste the court's time and resources and money. Let's just get on with it. And the promotion of growth and the development of the law of evidence. So not only is it to make sure that we're being fair, not only are we trying to save some cost and save some time, but we're also developing the law as we move forward. As we use the law, we develop the law. And to what end? That the truth may be ascertained and the proceedings justly determined. And who may determine questions of fact? The judges could talk about questions of law and debate questions of law, but ultimately questions of fact goes to a jury. And that's when I think about, the laws in America and how you're supposed to, there's some, dumb, petty things, and then there's some big things. Ultimately, I ask the question, what would a jury of my peers say? If it's, 6, if it's a misdemeanor, 12, it's a felony. What would a jury of my peers say? Oh, a big rig acted like he was going to drive up into your yard. Oh, that's crazy. Nobody would ever drive up into the yard. There's sagebrushes all over the place. Who would? Oh, you got video of somebody driving up into the yard. Oh, okay. Well, then people do that. People do threaten to drive up into the yard and then drive around your house. And I guess we're supposed to pretend that is, they're delivering some cake. They're delivering a blueberry pie. No, they got $20,000 for me to jumpstart my small business. Wouldn't that be nice to have a pot store right there, right around the corner? Also want to work on being a professor, journalist. Without safety, I guess I can't really. Anyways. So just imagine. And then there's that Ann Kelly, and then there's that Robert Willett. So for that, race, Robert Willett didn't give a shit about the fairness in administration. Robert Willett didn't give a shit about trying to eliminate unjustifiable expense and delay in the promotion of growth and development of the law of evidence to the end that the truth may be ascertained and the proceedings justly determined. Robert Willett didn't give a shit. And so you have to vote for Ann Kelly because she's a new pair of eyes. You got to get a new pair of eyes on this matter. None of these assholes, they want to put it on Alonzo Payne and act like it was just him. None of these assholes gave a shit about victims' rights. Robert Willett didn't care. The judges, the cops. It wasn't Alonzo Payne. He was just a scapegoat. Rule 103. Rulings on evidence. Effect on erroneous ruling. Error may not be predicated upon a ruling which omits or excludes evidence unless a substantial right of the party is affected and objection. In case the ruling is one admitting evidence, a timely objection or motion to strike appears of record, stating the specific ground of objection if the specific ground was not apparent from the context, or 2, offer of proof. In the case the ruling is one excluding evidence, the substance of the evidence was made known to the court by offer or was apparent from the context within which questions were asked. Once the court makes a definitive ruling on the record admitting or excluding evidence, either at or before trial, party need not renew an objection or offer of proof to preserve a claim of error for appeal. B. Record of offer and ruling. The court may add any other or further statement which shows the character of evidence, the form in which it was offered, the objection made, and the ruling thereon. It may direct the making of an offer in question and answer form. C. Hearing of jury and jury cases proceedings shall be conducted to the extent practicable so as to prevent inadmissible evidence from being suggested to the jury by any means, such as making statements or offers of proof or asking questions in the hearing of the jury. D. Plain error. Nothing in this rule precludes taking notice of plain errors affecting substantial rights, although they were not brought to the attention of the court. So there's plain errors, and then there's, forgivable errors? What do they call that? There's like errors that are terrible, and then there's errors that are forgivable. It's like, oh, come on, he just misspoke. He just didn't write, he didn't put the date on the thing, and so basically there's errors which are okay, and then there's bullshit technical errors, right? Oh, you didn't write, you didn't do the right form. You didn't do the right form, so ha. Nope, we gotta take your rights away because you didn't do there's a plain error. There's a difference between plain error and something else. Harmless error. Oh, I used the wrong form, but okay, the point is still the same, right? Oh no, since I'm the accused and I don't get any of the court system, felony ministers can menace me before and after. They can do dozens and dozens of times. And nobody's gonna say shit! You know how fucked up that is? None of the friends or family or neighbors can say, hey, I don't like when crimes happen to you. Oh boy, what a fucked up journey, huh? Just been scraping the bottom of the barrel. Rule 104, preliminary questions. A, questions of admissibility generally. Preliminary questions concern the qualification of a person to be a witness, the existence of a privilege, or the admissibility of evidence shall be determined by the court, subject to the provisions of subdivision B. In making its determination, it is not bound by the rules of evidence except those with respect to privileges. B. Relevancy conditioned on fact. When the relevancy of evidence depends upon the fulfillment of a condition of fact, the court shall admit it upon or subject to the introduction of evidence sufficient to support a finding of the fulfillment of the condition. C. Hearing of jury. Hearings on the admissibility of confession shall in all cases be conducted out of the hearing of the jury. Hearings on other preliminary matters shall be so conducted when the interest of justice require or when an accused is a witness, if he so request. D. Testimony by accused. The accused does not, by testifying upon a preliminary matter, subject himself to cross-examination as to other issues in the case. E. Weight and credibility. This rule does not limit the right of a party to introduce before the jury evidence relevant to weight or credibility. Rule 105. Limited admissibility. When evidence which is admissible as to one party or for one purpose but not admissible as to another party or for another purpose is admitted, the court upon request shall restrict the evidence to its proper scope and instruct the jury accordingly. Rule 106. Remainder of or related writings or recorded statements. When a writing or a recorded statement or part thereof is introduced by a party, an adverse party may require him at that time to introduce any other part or any other writing or recorded statement which ought in fairness to be considered contemporaneously with it. When a writing or recording statement or part thereof is introduced by a party, an adverse party may require him at that time to introduce any other part or any other writing or recorded statement which ought in fairness to be considered contemporaneously with it. Wow, I like Rule 106. I like that Rule 106. Article 2, Judicial Notice. Rule 201, Judicial Notice of adjudicative facts. A. Scope of rule. This rule governs only judicial notice of adjudicative facts. B. Kinds of facts. A judicially noticed fact must be one not subject to reasonable dispute in that it is either 1. Generally known within the territorial jurisdiction of the trial court, or 2. Capable of accurate and ready determination by resort to sources whose accuracy cannot reasonably be questioned. C. When discretionary, a court may take judicial notice whether requested or not. D, when mandatory, a court shall take judicial notice if requested by a party and supplied with the necessary information. E, opportunity to be heard. A party is entitled, upon timely request, to an opportunity to be heard as to the propriety of taking judicial notice in the tenor of the matter noticed. In the absence of prior notification, the request may be made after judicial notice has been taken. F, time of taking notice. Judicial notice may be taken at any stage of the proceeding. G, instructing jury. In a civil action or proceeding, the court shall instruct the jury to accept as conclusive any fact judicially noticed. In a criminal case, the court shall instruct the jury that it may, but is not required to, accept as conclusive any fact judicially noticed. Article 3, presumptions in civil actions and proceedings. Rule 301, presumptions in civil actions and proceedings. In all civil actions and proceedings not otherwise provided for by statute or by these rules, a presumption imposes upon the party against whom it is directed the burden of going forward with evidence to rebut or meet the presumption, but does not shift to such party the burden of proof in the sense of the risk of non-persuasion, which remains throughout the trial upon the party on whom it was originally cast. And they got Rule 302 here, and then it says no Colorado rule codified. So we got a little space there. And then, of course, according to Rule 302, we got more rules right. If I'm reading this correctly, Rule 302, no law. Well, that means we need more laws. Colorado, we need more laws. Article 4, relevancy and its limits. Rule 401, definition of relevant evidence. Relevant evidence means evidence having any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. Rule 402, relevant evidence generally admissible, irrelevant evidence inadmissible. All relevant evidence is admissible except as otherwise provided by the Constitution of the United States, by the Constitution of the State of Colorado, by these rules, or by other rules prescribed by the Supreme Court, or by the statutes of the State of Colorado. Evidence which is not relevant is not admissible. Rule 403, exclusion of relevant evidence on grounds of prejudice, confusion, or waste of time. Although relevant evidence may be excluded if its probative value is substantially outweighed by the danger of an unfair prejudice, confusion of the issues, or misleading the jury, or by considerations of undue delay, waste of time, needless presentation of cumulative evidence. Rule 404, character evidence, other crimes, wrongs, or acts. A, character evidence, generally evidence of a person's character or a trait of his character is not admissible for the purpose of proving that he acted in conformity therewith on a particular occasion, except one, character of the accused. In a criminal case, evidence of a pertinent trait of his character offered by an accused or by the prosecution to rebut the same, or if evidence of the alleged victim's character for aggressiveness or violence is offered by an accused and admitted under Rule 404A2, evidence of the same trait of character of the accused offered by the prosecution. Number 2, character of the alleged victim. In a criminal case, evidence of a pertinent trait of a character of the alleged victim of the crime offered by an accused or by the prosecution to rebut the same, or evidence of a character trait of the peacefulness of the alleged victim offered by the prosecution in a homicide case to rebut the evidence that the alleged victim was the first aggressor. 3, character of witness. Evidence of the character of a witness as provided in Rules 607, 608, and 1390, 101, 1390, 101B, other crimes, wrongs, or acts. 1, prohibited uses. Evidence of any other crime, wrong, or act is not admissible to prove a person's character in order to show that on a particular occasion the person acted in conformity with the character. Interesting. Evidence of any other crime, wrong, or act is not admissible to prove a person's character in order to show that on a particular occasion the person acted in conformity with the character. So you can't have a bad character witness? Is that what they're trying to say? Because it's kind of like, oh, he punched you that one day, but you're not allowed to say it. Why not? Because we protect the criminals? Because you protect the criminals? Is that what you do? You protect the fucking criminals around here. That's what you motherfuckers are doing. You motherfuckers are protecting the goddamn criminals around here. Number 2, permitted uses. This evidence may be admissible for another purpose, such as proving motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. Notice in a criminal case. In a criminal case, the prosecutor must A, provide reasonable notice of any such evidence that the prosecutor intends to offer at trial, so that the defendant has a fair opportunity to meet it. B, articulate in the notice the permitted purpose for which the prosecutor intends to offer the evidence and the reasoning that supports the purpose. And C, do so in writing before trial or in any form during trial if the court for good cause excuses lack of pre-trial notice. Rule 405, methods of proven character. Okay, so how are we able to prove the character? You can't say he punched in the face. What can you say? Well, number 1, reputation or opinion. In all cases in which evidence of character or a trait of character of a person is admissible, proof may be made by testimony as to reputation or by testimony in the form of an opinion. On cross-examination, inquiry is allowable into relevant specific instances of conduct. So you can't say he punched me, so he's got a bad character, but you can say, well, my opinion is, since he punched me, he's a bad piece of shit. You can give your opinion, but you can't. Okay, so B, specific instances of conduct. I don't know. We'll have to think about this a little bit longer, but this is the introductory reading. You got to read it first, right? How can you understand a thing if you haven't even read it? The Constitution is pretty short, too, Americans. Make sure you read your Constitution. B, specific instances of conduct. Carrying on with Rule 404, except as limited by Section 1610.301 and 18.3407 in cases in which character or trait of character of a person is an essential element of a charge, claim, or defense. Proof may also be made of specific instances of that person's conduct. Rule 406, habit, routine practice. That is actually evidence of the habit of a person or of the routine practice of an organization, whether corroborated or not, and regardless of the presence of eyewitnesses, is relevant to prove that the conduct of the person or organization on a particular occasion was in conformity with the habit or routine practice. Rule 407, subsequent remedial measures. When after an event, measures are taken which, if taken previously, would have made the event less likely to occur, evidence of the subsequent measures is not admissible to prove negligence or culpable conduct in connection with the event. This rule does not require the exclusion of evidence of subsequent measures when offered for another purpose, such as proven ownership, control, or feasibility of precautionary measures, if controverted, or impeachment. Rule 408, compromise and offers to compromise. A, prohibited use as evidence of the following is not admissible on behalf of any party when offered to prove liability for invalidity of or amount of a claim that was disputed as to validity or amount, or to impeach through a prior inconsistent statement or contradiction. Number 1, furnishing or offering or promising to furnish, accepting or offering or promising to accept a valuable consideration in compromising or attempting to compromise the claim. And 2, conduct or statements made in compromise negotiations regarding the claim, except when offered in a criminal case and the negotiations related to a claim by a public office or the agency in the exercise of regulatory, investigative, or enforcement authority. B, permitted uses. This rule does not require exclusion if the evidence is offered for purposes not prohibited by subdivision A. Examples of permissible purposes include proving a witness's bias or prejudice, negating a contention of undue delay, and proving an effort to obstruct a criminal investigation or prosecution. Rule 409, payment of medical and similar expenses. Evidence of furnishing or offering or promising to pay medical, hospital, or similar expenses occasioned by an injury is not admissible to prove liability for the injury. Rule 410, offer to plead guilty. Nolo contendere. Withdrawn pleas of guilty, except as otherwise provided by statute to the state of Colorado. Evidence of a plea of guilty later withdrawn, or a plea of nolo contendere, or of an offer to plead guilty, or nolo contendere de nolo contendere to the crime charge or any other crime, or of statements made in any connection with any of the foregoing pleas or offers is not admissible in any civil or criminal action, case, or proceeding against a person who made the plea or offer. This rule shall not apply to the introduction of voluntary and reliable statements made in court on the record in connection with any of the foregoing pleas or offers were offered for impeachment purposes or in a subsequent prosecution of the declarant for perjury or false statement. This rule shall be superseded by any amendment to the Colorado Rules of Criminal Procedure which is inconsistent with this rule, which takes effect after the effective date of these Colorado Rules of Evidence. Rule 411. Liability insurance. Evidence that a person was or was not insured against liability is not admissible. Upon the issue whether he acted negligently or otherwise wrongfully, this rule does not require the exclusion of evidence of insurance against liability when offered for another purpose, such as proof of agency, ownership, or control, or bias, or prejudice of a witness. Rule 412. No Colorado rule codified. No Colorado rule codified. According to Rule 412, Your Honor, there are no rules. Article 5, Privileges. Rule 501, Privileges recognized as provided, except as otherwise required by the Constitution of the United States of America, the Constitution of the State of Colorado, the statutes of the State of Colorado, rules prescribed by the Supreme Court of the State of Colorado pursuant to constitutional authority, or by the principles of the common law as they may be interpreted by the courts of the State of Colorado in light of reason and experience. No person has a privilege to 1. Refuse to be a witness, or 2. Refuse to disclose any matter, or 3. Refuse to provide any object or writing, or 4. Prevent another from being a witness or disclosing any matter or producing any object or writing. Rule 502. Attorney-client privilege and work product limitations on waiver. The following provisions apply in the circumstances set out to disclosure of a communication or information covered by the attorney-client privilege or work product protection. A. Disclosure made in a Colorado proceeding or to a Colorado office or agency. Scope of a waiver when the disclosure is made in a Colorado proceeding or to an office or agency of a Colorado state, county, or local government and waives the attorney-client privilege or work product protection. The waiver extends to an undisclosed communication or information in a Colorado proceeding only if 1. The waiver is intentional. 2. The disclosed and undisclosed communications or information concern the same subject matter. And 3. They ought in fairness to be considered together. B. Inadvertent disclosure when made in a Colorado proceeding or to an office or agency of a Colorado state, county, or local government. The disclosure does not operate as a waiver in a Colorado proceeding if 1. The disclosure is inadvertent. 2. The holder of the privilege or protection took reasonable steps to prevent disclosure. And 3. The holder promptly took reasonable steps to rectify the error, including, if applicable, following CRCP 26 B5B. What is that? CRCP 26 B5B? Let's take a look at it real quick. Let's have some fun. Who wants to have some fun here, huh? CRCP 26 B5B. All right. So, Rule 26, according to CRCP, Rule 26. I mean, what trials? Rule 23, and Rule 26 is before instructions. Rule 30 is instructions. Rule 26 is evidence. In all trials, the testimony of witnesses shall be taken orally in open court unless otherwise provided by law. And actually it does. The Constitution says you can go ahead and get the recording, transcribe a recording, get a deposition. Get the deposition of the witnesses. Immediately. Get witness statements. What the hell happened? What the hell was going on? All right, where is Rule 26? If Rule 30 is there, okay, Rule 26, evidence. That's what I just read in Rule 26.1 and 26.2, determination of foreign law and written records. That's deleted by amendment, so there's only Rule 26 and 26.1. And we're talking about Rule 26, right? Rule 26B, no, wait, yes, wait. There is no Rule 26B, you fucking assholes. B5B, Rule 26, evidence, B5B. It doesn't go B5B, you prick. So, I don't know which one they're talking about here. What, maybe a rule close by? Is it Rule 16? Are they talking about Rule 16? Let's see, Rule 16, B5B. Rule 16. Am I finding problems in the fucking law books already? Huh? I used to prove my math books wrong all the time. So let's see here. 26B, 5B. There is a B, but no 5 under that. So, okay, it wasn't Rule 16, but it's a different rule nonetheless. Because there is no Rule 26B, 5B, dickhead. God damn it. Thanks a lot, Professor John Barkai and Turner Wong. On page 9, it says CRCP 26B 5B, and there is no such thing. C. Disclosure made in a federal or other state proceeding when the disclosure is made in a proceeding in federal court or the court of another state and is not the subject of a court order concerning waiver. The disclosure does not operate as a waiver in a Colorado proceeding if the disclosure, 1, would not be a waiver under this rule if it had been made in a Colorado proceeding, or 2, is not a waiver under the law, or as 2 is not a waiver under the law governing the state or federal proceeding where the disclosure occurred. D. Controlling effect of a court order. A Colorado court may order that the privilege or protection is not waived by disclosure connected with the litigation pending before the court, in which event the disclosure is also not a waiver in any other proceeding. E. Controlling effect of a party agreement. An agreement on the effect of disclosure in a Colorado proceeding is binding only on the parties to the agreement unless it is incorporated into a court order. F. Definitions. In this rule, 1, attorney-client privilege means the protection that applicable law provides for confidential attorney-client communications, and 2, work product protection means the protection that applicable law provides for tangible material or its intangible equivalent prepared in anticipation of litigation or for trial. Got 3 more minutes. Can I finish the whole thing? No. But when I've got through goddamn almost half of it. Article 6, witnesses. Rule 601, general rule of competency. Every person is competent to be a witness except as otherwise provided in these rules or any other statute of the state of Colorado. Rule 602, lack of personal knowledge. A witness may not testify. A witness may not testify to a matter unless evidence is introduced sufficient to support a finding that he has personal knowledge of the matter. Do you have personal knowledge of the matter? Evidence to prove personal knowledge may but need not consist of the testimony of the witness himself. Well, I didn't see it, but I heard him say it. This rule is subject to the provisions of Rule 703 relating to opinion testimony by expert witnesses. Rule 603, oath or affirmation before testifying. Every witness shall be required to declare that he will testify truthfully by oath or affirmation administered in a form calculated to awaken his conscience and impress his mind with his duty to do so. Rule 604, interpreters. An interpreter is subject to the provisions of these rules relating to qualification as an expert in the administration of an oath or affirmation that he will make a true translation. Rule 605, competency of judge as witness. Competency of judge as witness. The judge presiding at the trial may not testify in that trial as a witness. No objection need be made in order to preserve the point. Rule 606, judge, you can't testify in this case. Shut the fuck up, judge. No, judge. Objection. Shut the fuck up, Judge Gonzalez. Rule 605 says you gotta shut the fuck up. You can't testify in this trial. Objection. Hearsay or something? No. Shut the fuck up, asshole. Rule 605. Nah, read it and weep. Nah, read it and weep. Nah, why don't you go give Bubba a rim job? Rule 606. Competency of jury as witness. At the trial, a member of the jury may not testify as a witness before that jury in the trial of the case in which the jury is sitting. No objection need be made in order to preserve the point. That's Rule 606. Competency of jury as witness. B. Inquiry into the validity of verdict or indictment. Upon an inquiry into the validity of a verdict or indictment, a juror may not testify as to any matter or statement occurring during the course of the jury's deliberations or to the effect of anything upon his or any other juror's mind or emotions as influencing him to assent to or dissent from the verdict or indictment or concerning his mental processes in connection therewith. But a juror may testify about 1, whether extraneous prejudicial information was improperly brought to the juror's attention. 2, whether any outside influence was improperly brought to bear upon any juror. 3, whether there was a mistake in entering the verdict onto the verdict form. A juror's affidavit or evidence of any statement by the juror may not be received on a matter about which the juror would be precluded from testifying. Rule 607, who may impeach? The credibility of a witness may be attacked by any party, including the party calling him. Leading questions may be used for the purpose of attacking such credibility. Rule 608, evidence of character and conduct of witness. A, opinion and reputation, evidence of character. Opinion and reputation, evidence of character.